The following BLTV program is brought to you by O'Flaherty Law. Please enjoy.
Welcome to Learn About Law. My name is Kevin O'Flaherty from O'Flaherty Law, and today we're going to explain what happens at adult guardianship hearings in Illinois. First, we're going to draw a distinction between an uncontested guardianship hearing and a contested guardianship hearing. An uncontested guardianship hearing occurs when the guardian ad litem, who is responsible for looking out for the best interests of the disabled adult, and all third parties involved agree that the proposed guardianship is appropriate for the best interests of the disabled adult. In an uncontested guardianship hearing, the judge will still review the guardian ad litem's report and the physician's report, but no witnesses will be called, and the judge will enter an order appointing the guardian as proposed. In a contested guardianship hearing, the hearing functions a lot like any other civil litigation. Like other litigation, pretrial discovery practice occurs, motion practice occurs, and all of the normal preparation for a trial that happens in a guardianship proceeding. The disabled adult has a right to a jury trial. At the trial, both parties will present documentary evidence as well as witnesses. Almost always, physicians and other expert witnesses are called by both sides, but you don't need to be a physician to testify. Lay witnesses, non-expert witnesses can testify. People close to the disabled adult can testify about their opinions about the disabled adult's abilities. And that's kind of different from a lot of other cases. The testimony of the family and close friends of the disabled adult is actually considered here. The burden of proof is on the party seeking to establish the guardianship to prove by clear and convincing evidence, which is a higher burden of proof than the normal preponderance of the evidence, that the guardianship is necessary and that the disabled adult actually has a disability requiring guardianship. Regardless of whether the guardianship is contested or uncontested, it's the court's duty to look into several factual issues. And this is why the court will review the physician's report and the guardian ad litem's report, even in an uncontested guardianship. So the court has the duty to inquire about the mental and physical abilities of the disabled adult, about the nature and severity of the disabled adult's disability, about the ability of the disabled adult to make and communicate responsible decisions, the ability of the disabled adult to manage his or her own financial affairs, and the appropriateness of any proposed living arrangement involved in the guardianship, as well as any other issue that the court finds to be important. So if the court makes this inquiry and decides that a guardianship is necessary, how does the court decide who to name as the guardian? And again, in uncontested guardianship cases, it's usually whoever files for guardianship, but the court will still make this factual inquiry. They'll look at a number of factors, including recommendations of family members, the relationship between the disabled adult and the proposed guardian, actions by the disabled adult prior to his or her disability indicating that he or she places a level of trust in the guardian. By the same token, actions by the proposed guardian that indicate, prior to the disability, a concern for the disabled adult's basically financial affairs and well-being. The proposed guardian's ability to manage the disabled adult's estate, other responsibilities of the proposed guardian that would conflict with his or her responsibilities as guardian for the disabled adult, and the proposed guardian's financial interest in the disabled adult's estate or any other impropriety involved in the situation. So the court will look at all those factors to determine that the proposed guardian really is a person who's going to look out for the disabled adult's best interest. So after analyzing whether the evidence presented by both sides, the arguments presented by both sides at trial, and cross-referencing them with the factors that the court's supposed to look at to determine whether a guardianship is necessary and who to name as guardian, the court will make a final determination as to, again, whether a guardianship is necessary, and if the guardianship is necessary, whether the proposed guardian is the appropriate person to be named as guardian for the disabled adult. So if you have any questions, please leave them in our comment section. Please subscribe to us on SoundCloud, iTunes, and YouTube. And feel free to give us a call for a free consultation at 630-324-6666. Thanks so much for listening.
Thanks for watching our video. If you have any questions, feel free to comment below. Click the subscribe button for new videos every week and download and review us on iTunes. Visit learn-about-law.com for other legal-related articles and videos. Visit our business podcast and video blog, seizeyourbusiness.com, and visit makingrealestatefun.com for real estate videos and podcasts. Call us at 630-324-6666 for a free consultation. Thanks for watching.